We're going to talk about religious freedom, parental rights in marriage. And I thought it would be interesting if I would tell you the breakdown of the political parties in the votes on the main cases in each of these areas. Because in presidential races, you always hear people say, one of the most important things is to make sure that we get good people appointed to the Supreme Court. And I'm just going to let you see how that's working out for us. Okay? In religious freedom, the case we're going to talk about in a bit is Employment Division versus Smith. The majority opinion here was against religious freedom. It threw religious freedom into the trash can, the free exercise of religion, to be precise. The majority opinion of 5 judges was 1 Democrat and 4 Republican appointees. There was a Republican person, Senator Day O'Connor, who concurred in the final decision about who wins and who loses, but she dissented strongly from the core reasoning adopted by the court, which is what's important. It's not who wins, who loses is of secondary importance as to the rationale. She still held religious freedom in high regard. She just looked at the facts differently. So there was 1 Republican on that side, and there were 2 Democrats and 1 Republican appointee in dissent. In the parents' rights case that we're going to talk about, Troxel versus Granville, 3 Republicans voted in favor of parental rights. 3 Democrats voted in favor of parental rights. Now, I have to pause and tell you, and we're going to see this in more detail, they voted in favor of parental rights in this case only, some of them. But only 1 judge voted for parental rights on a strong constitutional basis, and that was Justice Clarence Thomas. And so 8 of the justices of the Supreme Court were some form of either lukewarm or bad. Only 1 justice took a good opinion. But all 3 that took the bad approach were Republican appointees. In the marriage case, this was, we had 4 Democrats voting to legalize same-sex marriage and 1 Republican joining with them. Now, that Republican had been on the bench a long, long time, which is one of the best arguments for term limits for judges that I know about. All 4 dissenters were Republicans on that particular case. And so it's just really interesting. We think we're getting good justices. When Democrats appoint people, they're extremely reliable on the core issues of their constituency. When Republicans appoint people, we have no idea what we're getting. And so it's just, like, let's go draw somebody out of the hat. And that tells you a lot about where we're going on. All right, so let's begin with religious freedom. I've written a fairly long book on the history of religious freedom. It's actually been reprinted, and I updated it slightly. I originally wrote it about 7 years ago. The original version is called From Tyndale to Madison. If you have that book, you don't need to go out and buy the other one. The differences are small. But the new book is called The History of Religious Freedom, which is a better title, frankly. And if you go to CBD or the Christian Book Distributors or HSLDA, or just go look up The History of Religious Freedom, put my name in Google, you'll find some place to buy it, and if you want to. But I'll just tell you a brief outline of the story. Religious freedom started with the battle to publish the Bible. That's the battle that matters. And the hero that first articulated both the principles of religious freedom and self-government was William Tyndale. And William Tyndale, the great Bible translator, the King James Bible really should be called the Tyndale Bible. King James actually turns out to not be such a good guy as an individual. And, this is an old, the book of Romans, all things work together for good for those who love God. The Texas version of that is God can hit a straight lick with a crooked stick. And so King James was a crooked stick, but the King James Bible was a straight lick. It was a great thing. But 85% of the King James Bible, of the books that Tyndale translated, which is all the New Testament and most of the Old Testament, they killed him before he finished, was the work of Tyndale. And so he was a great man. C.S. Lewis said of William Tyndale that he accomplished more than any other English-speaking person in 500 years. So it's a remarkable thing that what Tyndale did. Tyndale argued for two ideas. One was every person had the right to do what the Bereans did and to be able to search the Scriptures to see if these things be so. Now, they were searching the Scriptures for the Apostle Paul, teaching them. So if you can search the Scriptures and check out the Apostle Paul to see if he's teaching you correctly, then there's no teacher, pastor, church that follows that shouldn't be subject to taking the Bible and checking and see if these things be so. And Tyndale made that argument with eloquence, and he paid for it with his life. He also argued that it was immoral to have the bishops make laws, because when the church made laws in those days, they were laws. It wasn't like for the internal operation of the church. You would go to jail for violating their laws. You would get burned at the stake for violating the laws. Or if they were humane to you, they would chop off your head. So that was their humane version of execution, whereas burning at the stake was a little more troublesome. But you're dead either way. And so the law of the church was the law. And he said that the bishops who made the law had, if they could serve our penalty in hell for us by making wrong laws, and we were forced to believe them, then it would be just. But if we're going to have to serve our own penalties in hell for following their doctrine incorrectly, we should have the right of self-government. And so the first person to argue the two core principles of the founding of America, religious freedom and self-government, was William Tyndale, arguing in the 1550s. And so that battle went on. I read a book. This is another really good book. It's a secular book, but it's a great book. It's called Wide as the Waters by Benson Bobrick. And it was his book that got me interested in this. He wrote about the Bible translators. And he took the book up to about 1680, and he stayed in England. But as he was doing that, I noticed that every provision of the Bill of Rights was found to be necessary in the battles that were going on for the Bible. Why do we have the petition for redress of grievances? There was a petition called the Millennial Petition, where people asked the King James, when he came on the throne, to purify the church in certain ways. And he refused to do so. And he said he punished those who had circulated the petition. So people didn't want people to be punished for circulating petitions. And that example of the Millennial Petition that King James punished people for was in the minds and in the knowledge base of the Founding Fathers. And there are many, many more examples like that. Benson Bobrick didn't correlate it to the First Amendment. I saw the correlation. I went back and redid all the English history, but then I jumped the channel and, or jumped the ocean and came over here, and we did the history from the beginning of the colonies to the beginning of America. It is not true that the American colonies came here for religious freedom. Not true, with the exception of the Mayflower. The Mayflower were separatists. The difference between separatists and Puritans is not a small difference. It is a huge difference. Separatists do not believe that there should be a state church. Why? Because they believed that salvation was between the individual and God, and the state could not dictate the means of salvation. That is not a small difference. The Puritans believed the state could dictate the means of salvation, just do it their way, rather than somebody else's way. That is not a small difference. That is a huge difference. So when the Puritans came to America and took over Massachusetts, and the separatists kind of died away, they were not here for religious freedom. They were here for a religious sanctuary for themselves. And Virginia was not a secular colony, as people would think. The two most important colonies in the early days were Massachusetts and Virginia. Virginia was very much a religious colony. You were punished dramatically for failing to go to church. The compulsory attendance laws didn't start with the public schools. There were compulsory attendance laws started with church rules. And if you didn't go to church in Virginia, the first time you were fined a large amount of tobacco, but then eventually you were put on a slave ship to roll in the galleys for 6 months or a year. I forget the exact time, but for a long time, as you were basically put in prison to row boats. It was a very dramatic, religious, oppressive colony. They were not coming here for religious liberty. They came here for religious sanctuary for themselves. Completely different thing. So the first rule of religious liberty is religious freedom. If it's not for everybody, then it's not for me. And here's the problem. I am a pretty conservative person theologically. I'm an ordained Baptist pastor. But I've been going to non-denominational churches virtually all of my adult life. I grew up in a Baptist church, and I was ordained by a Baptist church, but of the 44 years Vicki and I have been married since we were 6, all but about 4 years were in non-denominational churches. But I'm very conservative theologically in a lot of ways. If the government's going to decide which kind of theology is going to get punished, I'm going to be in their crosshairs. And so is everybody in this room. And so the founders really did believe that religious freedom for everybody. It doesn't mean there aren't limits, and we're going to talk about those limits in just a second. Because the real key, and we're not going to talk as much about the Establishment Clause, because the Establishment Clause is about how much religious promotion the government can do by, praying at the beginning of congressional sessions and publishing Bibles for the chaplain's corps and those kinds of things. Those are Establishment Clause issues. And they're important because a nation that acknowledges God is blessed. But I've spent my life not on Establishment Clause issues, but on free exercise issues, which is what can the church do? Not what the state can, promote religion. Is the church going to remain free? Are families going to remain free to raise their kids? Those are the issues. Free exercise is far more important on a day-to-day basis for Christians than the Establishment Clause issues ever would be. And we just have to pick and choose because, I don't have 40 hours with you, and so we're going to just talk about free exercise today, which I do believe is the more important of the two issues. How did the founders balance it? Because if free exercise is for everybody, what's the limit? Because we do not want people executing people under Sharia law in the name of religious freedom. No, that's not religious freedom. That's abuse. That's murder. And it should be criminally prosecuted. Your religion notwithstanding, it provides no excuse for you whatsoever. And just, if somebody was... I hope that nobody's a snake handler here because it's bad theology, and I'm deathly afraid of snakes. The Bible says, I will put enmity between you and the serpent. If you want to see the embodiment of enmity, that's me. When I ran for lieutenant governor of Virginia, my campaign driver thought it'd be funny to stick a garter snake in my face as we were pulling out of a parking lot. I jumped from the moving car. I am that afraid of snakes. But if there was some snake handling group, that violates the moral law of something. So there are limits to religious freedom. What did the founding generation think were the limits to freedom? And the best distillation I ever saw in one place was a speech given at what's now Brown University. The state of Rhode Island was the Baptist state, which was the one that most consistently, from its very beginning, stood for religious freedom for everybody. And a student at what's now Brown gave a commencement address about religious freedom before it had been approved in this country, before the First Amendment was adopted, before we had really gotten away from the established church and so on. And he said this: the soul is absolutely exempt from the government. Anything relative to the soul. And our actions are exempt, our religious-based actions are also exempt from government regulation, except when our actions violate the moral law of God. religious freedom being a moral law of God, by its nature, cannot violate the moral law of God in other behavioral areas. So murder violates the moral law of God. It is never a proper exercise of religious freedom to commit murder in the name of religion. Burglary, theft, sexual crimes, whatever you want to say in the name of religion. But, it doesn't mean anything illegal. I've violated the law of Washington State by homeschooling my kids when it said you had to be a certified teacher to do it. My wife had been a certified teacher. She overcame that handicap, and her certification had lapsed, so we were technically illegal when we started homeschooling our kids. And by the time, if we'd have stayed in Washington State, by the time they were in junior high, would be illegal because her certification was elementary school, even if it was current. And so you can make anything illegal. You can make parking tickets a crime. I got $3 million worth of parking tickets declared unconstitutional in Spokane, Washington one time. They weren't all mine, but so you can make anything a crime. So it's not a fair thing to say religious freedom, you can do anything you want except for a criminal activity, because they can make praying a criminal activity. And so the boundary is you should be able to practice your religion in any way you want, provided that you do not violate the moral law of God. That's in our legal system used to recognize it in an area of crimes called, there's crimes that are malum prohibitum and crimes that are malum in se. Lawyers do this so we can charge you a lot of money just to use big words that mean really simple things. Malum prohibitum means it's wrong because it's prohibited. Malum in se means it's intrinsically wrong. And so crimes that are malum in se are another way of saying violations of the moral law of God. It's inherent in the nature of the way we've been created, which is what is consistent with our Creator's heart law, the law that He's laid on our heart. So that's the correct limitation on the principle of the exercise of religion. And so the Supreme Court struggled with that, and their version of the limitation was the compelling interest test. This is until 1990. And it said, you could do anything your belief, absolutely protected. And so the right to believe, you can believe whatever you want. The right to act on your belief, teaching your kids would be acting upon your belief. Refusing to bake a cake for a homosexual wedding would be acting upon your belief, and so on. So acting is where we normally get in trouble. I mean, the government could try to intrude belief, but mostly it tries to regulate actions. So you can act on your beliefs any way you want, unless there's a compelling governmental interest to stop you, which any moral law of God violations would always be a compelling governmental interest. There's always a compelling governmental interest for stopping murder and burglary and theft and all the other moral law of God issues. All of them would satisfy the compelling interest test. But other things creep in and can satisfy the compelling interest test. And the Supreme Court has made up this test out of thin air, but it is currently the highest test for constitutional rights. And in simple terms, it means this. Before the government can take away your right and say there's a justification for limiting your right, it's got to be a really, really, really important issue. And the government's program has to actually fulfill that goal. It can't be just having a goal and a program that doesn't achieve the goal. So there's got to be a high goal, a program that actually achieves the goal, and the burden of proof that the goal is high and that it's achieving the goal is all on the government. The burden is on the government. When you don't have fundamental rights doctrine, the compelling interest goes with the fundamental right. Non-fundamental rights get the rational basis test, which means if the government has a good excuse, they can violate your rights. I mean, I hate to be so blunt, but that's basically what it means. And the burden on you to show that it's not rational is on you, not the government. And so determining whether something's a fundamental right or a non-fundamental right is a really big deal. The founders would have thought all of our rights are fundamental. By the way, property rights, according to the Supreme Court, are non-fundamental. And so you ask the Founding Fathers that, which do you want? Freedom of press or property rights? They would have said, you touch either of them, we're going to exercise our Second Amendment right. So they would have not chosen between those two. And in practical terms, you ask the average American, do you want freedom to make decisions about your own property, or do you want the New York Times uncensored? They'll go, well, I really don't want the New York Times to be censored, but if I have to choose, I'm going to choose my own property. It's more important to me on a daily basis. And so the Supreme Court, in trying to search for that limitation, created the compelling interest test. And it's worked pretty well. For example, in Wisconsin versus Yoder, where the Amish wanted to homeschool their kids after the 8th grade. They sent them to the public schools to the 8th grade, and then they wanted to do vocational, hands-on, what amounts to vocational homeschooling after that point in time. And the Supreme Court ruled in their favor. They said, as important as the interest in compulsory education is, it's not so important that it overrides the Amish belief in exercising their religious freedom here. So it can really work. It yielded correct outcomes most of the time. So it was in operation, it was a pretty decent test, even though conceptually is a little flawed. So, but I would give it kind of a A-B+ in a functional sense. But then we came to Employment Division versus Smith. Now, the Supreme Court carefully chose that case on purpose because I had a case that was there at the same time, and it wasn't important just by me saying it was that important. The case was, the press called it Scopes 2. The Scopes, and the USA Today did a front page, or how they do their editorial pages. Sometimes they devote the whole editorial page to a topic. They devoted an editorial page to my case that was in litigation twice. I was on in every newspaper in the country. I was on every television network in the country. The London Times was at our trial. Papers from all over Europe. And when the Supreme Court denied review of the case, the denial of review made the front page of the New York Times, the Washington Post, and a whole lot of other papers. You don't get turn downs from the Supreme Court on the front page news on something that's trivial. It was a big, big battle. And the facts were, Christian kids got kicked out of public schools in East Tennessee for refusing to read textbooks that the school district stipulated violated their religious beliefs. And the question was, can you force kids to come to the public schools and coerce them to read books that the school district admits contravenes their religion? And in that factual context, the court would have had to take up the free exercise case. The other factual context in a case coming up at exactly the same time was Employment Division versus Smith. In that case, we had 2 Indians in Oregon, Native Americans in Oregon, who were drug counselors. They took illegal drugs. They were drug counselors. They violated the law of Oregon on taking drugs, period, and they got fired from their job as drug counselors, and they applied for unemployment compensation. And the question in the unemployment compensation was whether or not firing drug counselors for taking drugs was good cause. Bart Simpson and Thomas Jefferson would have agreed, although they would have expressed it differently. Jefferson would have said, we hold that truth to be self-evident. Bart Simpson would have said, like, duh. And same thing, one's more eloquent. And so nobody expected the drug counselors to win. Nobody. But nobody expected the Supreme Court to use that case to trash religious freedom for everyone. But they carefully chose that case, but because they didn't want this case with kids and books and conservative Christians, because they would have had marches on Washington if they'd have done it in that context. So they chose the Indians and the drugs, but we didn't fall for it because we knew that even though we didn't think the Indians would win, that the legal principles announced by the Supreme Court were deadly for everybody. And the principle that they announced was this: you cannot get a religious exemption from a neutral law of a neutral general law for religious purposes. Let me translate that. If the law says no discrimination on the basis of gender in hiring, the Catholic Church, my church, lots of conservative Protestant churches takes the position only men can be pastors. That is sex discrimination in employment. And you can't get a religious exemption from a neutral law of general applicability, meaning a law that wasn't aimed at religion in the first place. If there's a law that said you can't worship golden calves, well, that would be a law aimed at religion. Or if the law said all churches have to not discriminate on the basis of gender, that would be aimed at religion. But if the law says no employer can do this, that's a neutral general law. I'll give you another example. It's against the law in every state to serve alcohol to minors. In an Episcopal church, for example, they serve communion, real wine. And if a 15 or 17-year-old kid, or for that matter, a 19-year-old kid, takes communion, that is a technical violation of the alcohol control laws of that state. And if there was a sheriff or a prosecutor stupid enough to actually arrest the Episcopal priest for doing that, there would be no constitutional defense as a result of the Smith decision, because the no serving alcohol rule wasn't written for churches. It's a neutral general law, and you can't get a religious exemption from a neutral general law. No discrimination on the basis of sexual orientation in employment. Some places have that law. Patrick Henry College will never knowingly employ a homosexual. If we know they're homosexual, they're gone. If we know it before we hire them, we're not going to hire them. If we know it after they come, we're going to fire them on the spot. That's what's going to happen. And if Patrick Henry College gets sued for that, according to the Smith decision, there is no religious freedom protection. That's why the bakers and the photographers and the florists are in trouble, because the Smith decision said there's no religious exception for a neutral general law. You got it? Now, we didn't like that, those of us that know anything about religious freedom, and so there was a meeting held in one of the House office buildings a few days after this decision. And it was a very interesting coalition of people. How many of you have ever seen the original Star Wars movie? Lots of you? Okay, all right. There's a cantina scene where Luke walks in and there's all these weird people. And that was the meeting. I was Luke Skywalker. The ACLU had woo coming out of their head. Okay? Now, when they tell the story, they were Luke Skywalker and I was the weirdo. But what really happened was this. The Jewish community correctly understood the implications of this decision. And they called all their political capital in and told the ACLU and the other leftist organizations they were going to support us in this effort to do something about this case. And so there was the most interesting coalition ever to draft what became known as the Religious Freedom Restoration Act, which is the bill that Hobby Lobby successfully used to defend its religious freedom about 1.5 years ago. They should have been able to use the Free Exercise Clause, but because of Smith, they couldn't. And so the guy that named the Religious Freedom Restoration Act is me. Now, it sounds more fancy than it was. Somebody said, so what are we going to call this thing? And there just had been a bill that went through Congress called the Civil Rights Restoration Act. And I said, let's call it the Religious Freedom Restoration Act. They said, that sounds good. Boom, on to the next thing. That was the entire discussion. So, it wasn't like we had a study committee or, it was boom. So I named it. And then they appointed 2 committees, a steering committee to run the whole operation, and then a drafting committee to actually write the bill. I was the chairman of the drafting committee. A couple weeks later, Mark Stern from the American Jewish Committee was added as a co-chairman. So Mark and I worked together, and we led the drafting of the Religious Freedom Restoration Act. And I was also on the steering committee to get it through Congress. It took 3 years, and we got it through. And then the Supreme Court struck again. They said that Congress could not grant more rights, more protection for the rights of the people than the Supreme Court granted in its interpretations, which means that not only is the Supreme Court the final interpreter of the Constitution, they say that they're the only interpreter of the Constitution. By the way, in Marbury versus Madison, where they discovered the right of judicial interpretation, they said it's because we take an oath to support the Constitution. Like, duh, so does Congress. So does the president. So does every member of the military. So does a lot of other people. It doesn't mean you get the only because of your oath. Come on, let's just, when I teach constitutional law at Patrick Henry College, first day, I wrote the word logic on the board, and then I draw a big red circle around it, and I put a red slash through it. I said, okay, now that you know that logic is demand, we're prepared to read Supreme Court decisions. So, so that they held, it took a couple of cases to get to the final result, is the Religious Freedom Restoration Act was still valid and binding when the federal government violated religious freedom, but it is not binding when the states violated religious freedom. About 20 states have adopted Religious Freedom Restoration Acts. When Indiana tried to do this last year and the whole world exploded, they were in fact following exactly the same legal rules that were in the original law that I helped to write, the ACLU helped to write, People for the American Way helped to write, and all of them supported it then. But when they realized that homosexuals might not be able to coerce everybody to bow the knee at their wedding altar, they flipped and they want to oppose religious liberty because, their argument was, we just want to be left alone. No, they don't. They want everybody to bow the knee at their altar. That's what that's all about. So the protection for religious freedom today is on thin ice. But if you have to argue it, here's how you argue it. You either argue that you've got another constitutional right that's kind of related to it, like the freedom of association. And I would be, if I had to defend a church, I would be arguing freedom of association as my lead right, or freedom of speech or something else. Because free exercise standing by itself is essentially gone. The other thing we can do, if it's the federal government, the RFRA is great. You can win cases under RFRA. State laws, if you have a state RFRA, you're in pretty good shape. Some state Supreme Courts are interpreting their state constitutions to be like the old rules of the Supreme Court before Smith, and that's a good thing, because the state constitutions were the original reason for the Bill of Rights, and one of the arguments Hamilton makes in Federalist 84 is why they didn't need a Bill of Rights, was we have state bills of rights. We don't need a federal one. And so, frankly, I'm glad, by the way, that they eventually changed their mind on that and decided to have a Bill of Rights. Think of what gun rights would be today if we didn't have the Second Amendment in black and white. Yeah, so I get the argument, and I think his premise about what he was worried about was a valid premise. But nonetheless, I'm glad that God led them to do what they did, and they eventually adopted the Bill of Rights. So that's where we are in religious freedom. Let's go to marriage. No, let's go to parents' rights first. Okay. The parents' rights is an example of another question the Supreme Court tries to figure out. And that is, when the Ninth Amendment says, and I'm going to give it to you in a paraphrase, just because we wrote down these other rights, it doesn't mean that the other rights that we have right now don't also get protection. Okay? And so they acknowledge that we have unenumerated rights. Enumerated meaning numbered, listed. So what rights are validly protected under the doctrine of unenumerated rights? Because unenumerated rights are where we got Roe versus Wade. Unenumerated rights are where we got the marriage case. And so getting unenumerated rights correctly is a really big deal. Justice Scalia rules against parents' rights. He says parents' rights is a political idea. He's one of the strongest supporters, and he's right. But he says there's no judicial protection for parents' rights because they're unenumerated. Okay? That's his view. It's not my view, but at least I understand. It's logical. It's logical. And so, but getting this done correctly is difficult. So here is the way I believe it should be answered. Number one, when they wrote the Ninth Amendment and said, just because we didn't write it down doesn't mean we have these rights. What rights were so well recognized in our legal system as of the date of 1791 when the Ninth Amendment was adopted, that it was not a little bit recognized, it was overwhelmingly recognized to represent a constitutional consensus in our nation. And you would look at state laws at the time, you would look at state court decisions at the time, you would look at the various factors that are equivalent of the Federalist Papers newspapers and so on to see what is historically grounded and was highly recognized and practiced. By the way, that's how you did it in the day in international law. It was called customary international law today, or the law of nations then. That's how you figured out what the law was in a lot of areas. And so it's not a contrary, it's the way common law works as well. And so even though constitutional law is not common law, the methodologies are similar in the area of unenumerated rights when done correctly. What rights were so well recognized in 1791 or when the 14th Amendment was adopted, because that's where the states were brought in to guarantee our fundamental rights. What rights were so well recognized in 1868 that they rose to a constitutional level of consensus in our practice and in our law. The only thing that I've ever been able to think of that would make that list is the right of parents to direct the upbringing and education of their children. Homosexual rights will never make the cut. Why? It was illegal to practice homosexual behavior. So there was no, in Bowers versus Hardwick, which was the case, Jenna talked about Lawrence versus Texas. Bowers was the case that Lawrence was reversing. When the Supreme Court listed all the laws of 1791 and the laws of 1868 on homosexuality, they took it word for word out of a brief that I was the lead author on. Now, they didn't credit it, but you can go back to my brief, compare it, and it's word for word. And I don't mind them plagiarizing my stuff because they ruled correctly. It's okay. So the law is very clear. Parental rights make the list. I can't think of anything else. It doesn't mean there would, but the methodology would test. Any claim of an unenumerated right, the correct methodology is what was so well recognized in 1791 and 1868. Does that mean we can never have any new rights? No. It just means we have to adopt them the correct way. We're going to adopt them by the amendment processes, either in the state constitutions and state bills of rights or in the federal Bill of Rights. We're going to adopt a constitutional amendment doing it the correct way. But the reason we will never have, the abortionists knew they would never get the right to an abortion, the right to kill babies, if they would do it the correct way. It theoretically could be adopted. It would be immoral to do so. We'd be violating the law of God. But just under the strict legality approach, they could do it. But they won't do it because the moral law of God is too well written on the hearts of the American people, and it's not politically possible to do that. Same thing is true same-sex marriage. The only way they got same-sex marriage in this country is it was imposed by the Supreme Judicial Court of Massachusetts, and it spread from court to court to court to court. Every time the people got a vote on it for a long, long time, was the people voted against it. They started to change only after the culture started to change as a result of the court decisions. So there have been a couple of states that voted the other way, but it's all been very recent after the judicial tyranny culture change had already been in place a long time. When the people were able to vote, the day President Obama was voted in the first time, California voted overwhelmingly to Proposition 8, approve same-sex marriage, not approve same-sex marriage, but only approve traditional marriage. And so, in fact, everybody understood that the Obama election made that successful because the African-American community that turned out in force to vote for President Obama also turned out in force to protect traditional marriage. And so it was because the African-American community holds the same views as other evangelicals on moral issues. And so they did a great thing in California there. The people agreed. The heart of God was on the minds of the voters, and the heart of God was reflected in the votes of the people on that issue. And so the whole area of unenumerated rights is a big, big deal. The Supreme Court started parental rights, unenumerated rights, in a case called Meyer versus Nebraska in the early 1920s, where the state of Nebraska made it illegal to teach children below high school level in a foreign language. And in a private Lutheran school, they taught Bible classes in German. And the teacher was criminally prosecuted for teaching the Bible in German to Lutheran kids in Nebraska. And And so the Supreme Court held that to be unconstitutional, that it violated the right of parents to choose how their children would be educated. Thank you very much, go away. 2 years later, approximately, when the Ku Klux Klan and the Scottish Rite Masons joined together to ban all private schools in Oregon because they hated Catholics and other minorities, but mainly Catholics they were aiming at. They banned all private schools in Oregon. And the Supreme Court of the United States ruled the right of parents to direct upbringing and education of their children is a fundamental right. Now, they did not ground it in history. They just grounded it in their own internal view as judges. They could have grounded it in history. They could have done it correctly, because if you do the analysis correctly, what rights were so well recognized in 1868 and in 1791 that would achieve this historical level of being a properly recognized unenumerated right, the same outcome in the case. But when you say, we as judges just declare this to be so, what you do is you create the right answer to the case, but you create the premise that judges get to decide what rights, unenumerated rights, get recognized. And that's the reason that the parents' rights cases led to the adoption of Roe versus Wade. It's a straight flow from that. And they cite Pierce as authority for their holding in Roe versus Wade. So when we are engaged in anything in life, but in the area we're talking about today, in constitutional law, I always teach my students, there's two things. You got to do the right thing. You got to do it in the right way. It's not enough just to do the right thing. You got to do it in the right way. And so we need to make sure, and so the Supreme Court did the right thing in that case. They did it in the wrong way, and there were consequences that arose from it. Now, the Supreme Court messed up parental rights in the Troxel versus Granville. Now, I am going to age you all, or we're going to have an age test. How many of you have ever heard the song, I'm Mr. Blue? Our guardian star has lost all its glow. You know that song? The guy that sang that was Gary Troxel. And he was the grandfather in this case that went to the Supreme Court. Troxel had a son who fathered a child out of wedlock, although the couple lived together for years and years and years. So, you know, they were raising it as a couple. But their son died, and the mother didn't want Gary Troxel to have visitation, or his wife. I don't know the reasons, but she didn't want them to. She thought they weren't fit and proper people to be around her kids. The law of the state of Washington said that any person who wanted to visit kids could come in and argue that they should be able to visit the kids if it was in the best interest of the child. How many of you have heard the phrase best interest of the child ever in a kind of a legal context? Many of you, okay. Needed some explanation. The best interest of the child standard answers the question who, not what. Not what is best for a child, but who gets to decide what's best for a child. And so the best interest of the child standard for 400 years has been this. When the family is broken by either a divorce or abuse or neglect, and there's proof of brokenness in court, of divorce or abandonment. So one of the ways the family is broken, where the parents either are in a divorce together or there are abuse issues, then and only then is the best interest of the child standard applicable. It's what lawyers call a dispositional standard, not a jurisdictional standard, meaning you go to jail for 10 years, disposition. You are guilty, jurisdictional. We take jurisdiction over you because you're guilty of burglary. Disposition, you go to jail. So the best interest of the child standard is a dispositional standard, means it's what after we've determined that the family is broken, then we say, okay, now we got to decide what's best for this kid. But unless the family's broken, you don't get to. And there was no evidence the mother was doing anything wrong with their daughter. And if the mother was doing anything wrong with their daughter, she gets to decide whether the grandparents should visit the kids or not. Even if she's, even if you or I would agree with her or not. It doesn't matter. It's not our call. She's the mother, not you. The judge is not the mother. She's the mother. And until she's proven to be unfit by abuse or so on, she gets to make the call. That's what the Supreme Court of Washington ruled. It was appealed to the U.S. Supreme Court. One judge, Clarence Thomas, agreed with that. The others messed around and did lukewarm endorsements of parents' rights or said parents' rights don't exist at all. Many of the judges said parents' rights exist, but they're non-fundamental rights. And I've already taught you what that means. It means the government can come over the top of you pretty much anytime you want, and you have the burden of proving otherwise. And so this case was the reason that I launched the effort to get the Parental Rights Amendment into the United States Constitution. And so that's ongoing. We are working right now. If you want any information about this, go to parentalrights.org. That effort is ongoing and trying to fix that. Marriage. We're going to go to marriage. Now, I've told you parts of the marriage thing already as we built up the fundamental rights, non-fundamental rights doctrine. But let me tell you the inside politics story on this, at least part of the story. There was a meeting at the Dallas airport about 1995, could plus or minus a year. And all the top leaders that I can remember anyway, it's been 20 years ago, were at this meeting. Dr. Dobson was there, as I recall. Chuck Colson was there. The LaHaye's were there, I believe. I know for sure Jay Sekulow was there. Don Wildman from American Family Association was there. There were about 40 of us. And I said it was like the 4-star generals, the 3-star generals, and so on. And they let a lieutenant colonel like me come too. And so everybody got to say what they thought should be one issue that our movement should address that was very important. And so it's 40 people, 40 ideas. And when it was my turn, I said this. Now, I've already told you I'm an ordained Baptist pastor. Baptist pastors are not allowed to have the gift of prophecy. So on page 73 of the Baptist rule book, if you have the gift of prophecy, it might lead to dancing. And so, but nonetheless, this is what I said. Bowers versus Hardwick was the law of the land at the moment in terms of judicial decisions. If states wanted to punish homosexual behavior, they could do so. But I was reading the legal literature and seeing the cases that were being filed and the law review articles. I was seeing the trends in the law, and based on that, this is what I said. There's going to be a day real soon where Bowers versus Hardwick is reversed by the Supreme Court, and they're going to say the practice of homosexuality is a constitutional right. States are going to use their state constitution. State courts are going to say that the right of equal protection in their state constitutions is going to be a equal protection right under their state constitutions. They'll do it under their state constitutions at first, so they're not reviewable by the Supreme Court of the United States until they get more momentum. And then eventually, a federal district court is going to rule that the right under the Equal Protection Clause of the 14th Amendment of the U.S. Constitution guarantees same-sex marriage, and then the Supreme Court of the United States ultimately will approve that, and we will have same-sex marriage in this country. The only way to stop this is to have a federal amendment on marriage, because the only way you override the 14th Amendment's Equal Protection Clause is with a law of an equivalent rank, meaning another amendment to the United States Constitution. Jay Sekulow, who was in the room, agreed with me. We were the only two constitutional lawyers in the room. I don't remember who it was, but one of the 4-star generals said, Mike, you've got a solution in search of a problem, and when the problem is acute, then we'll deal with it. If we dealt with the problem in 1995, the culture was still on our side, and we would have won. We could have adopted a marriage amendment then. And we didn't. And we waited, and once we tried it, the people that tried to push the marriage amendment originally. I was in the room for a long time until they decided they were going to put civil unions into the marriage amendment, allow civil unions. In the California civil union law, for example, said that homosexual couples getting a civil union had 100% of the rights of a legal spouse. If it wasn't about hospital visits or anything silly like that, which nobody cares who is anybody in the hospital. Who cares? But giving 100% of the rights of legal spouse, that's giving it marriage. Now, what I said at the time was, you can call it cantaloupe soup, but if you get 100% of the rights of a spouse, it's marriage. And so I opposed the coalition's effort to put civil unions into the Constitution, and Bill Bennett and Phyllis Schlafly and CWA and I walked out of their coalition, and it failed. They never were able to get a vote. Our own movement killed traditional marriage by failing to act in a proper time. It was not lost this last year. It was lost with Lawrence versus Texas. And let me tell you why it was lost in Lawrence versus Texas, which was 12 years to the day prior to the decision of Obergefell. Justice Scalia, in his dissent in Lawrence, said, if you don't recognize that they've just legalized same-sex marriages, you don't know how to read Supreme Court opinions. I'm paraphrasing, but you go read it. That's essentially what he says. We lost it in in Lawrence by this. About a week after Bowers versus Hardwick was decided, Justice White, his clerks had taken the stuff from my brief and written the really good opinion that I like. I saw him in Dulles Airport with his wife, apparently going on vacation. The court's term was just over, and it was less than a week, and the media was still abuzz with all this, and the homosexual community was all upset. And I went up to Justice White and shook his hand and introduced myself, told him I'd written a brief in the case, and I just really appreciated his opinion. And he said, you're probably the only person in America that thought so. And I said, no, Justice White. There are millions of Americans who agree with your opinion. He goes, I don't know. And his wife looked at me and shook my hand and said, I want to thank you very much for speaking to us. Translation, he was getting the daylights kicked out of him in his social circle. That's what was going on. People were not supporting him. And in the legal circles that he ran in, he was a persona non grata. I'll tell you another story that relates to it. 1984, I tried a case between a Christian mom and a homosexual dad involving lots of issues, including there was a criminal trial for kidnapping. She ran when the judge granted custody to her husband. The mom took a pretty long visitation period, it was 18 months. And she was charged with custodial interference, which is a form of kidnapping. I defended it on the basis that she was trying to protect her child rather than harm her child. And on that basis, it was ultimately dismissed. But when we were picking the jury for the criminal trial, I asked every juror in San Diego, not San Francisco, in San Diego in 1984, do you know a homosexual and do you know a born-again Christian? Every single juror, San Diego, 1984, knew a homosexual. One juror out of the whole pool, one knew a born-again Christian. Now, as I thought about that later, there is no way that these people didn't know born-again Christians. But I concluded that the born-again Christians were less transparent about who they were than the homosexuals were about who they were. And so they knew a born-again Christian, they just didn't know that the person actually professed faith in Christ. So if you want to know where the failure was, there is the failure, right there. It was representative in that jury in 1984, 32 years ago. Our silence is the reason we're in this mess that we're in today. So, these areas are all dramatically wrong. We're going to take a 10-minute break. After the break, I'm going to tell you not how we're going to reverse these decisions by an amendment on a marriage or religious freedom or anything. We're going to talk about how we're going to rein in the abuse of power by the Supreme Court on all subjects by adopting a new structure that will solve pretty much all the problems I've talked about today. The federalism problems, the General Welfare Clause problems, the Commerce Clause problems. We have a solution that's as big as the problem. You got to come back after the break, so don't go away, and we'll hear it in 10 minutes.